Every criminal case generates two stories. The story the evidence actually supports, and the story that gets told. I'm Melissa Diedrich, and this is Mind Motive Media. Welcome back, or just welcome to those tuning in for the first time. I'm glad to be here with you. This episode, we're going to spend most of our time in the courtroom. But instead of looking at a confession that nobody should have believed, this case has no confession at all, no eyewitnesses, and no weapon. This time we have two competing stories revolving around a staircase, told through blood evidence, and a bit of a rabbit hole that I'm going to drag you down with me. But let's just start with the facts. December 2001, police dispatch in Durham, North Carolina, received a call from a man distraught, saying that his wife had fallen down the stairs inside their home and was barely breathing. When officers arrived, they found her at the bottom of the staircase in a slumped position, already dead. They noted blood spatter and smear marks on the surrounding walls up to about 5 feet, and blood smears on a door frame leading in from outside. The autopsy revealed 7 deep scalp lacerations, and she had her own hair clutched in both hands. And worth noting, one hand had pine needles stuck to it, and her left hand had 3 small feathers clutched in it. No undisputable weapon was found near the body, and no witnesses turned up. The husband was targeted immediately and ultimately charged with murder. The pretrial publicity on this case was so intense, it took 8 weeks to seat a jury. And just for perspective, most murder cases take maybe 1 to 2 weeks, 3 tops, on average. At the trial, the case rested on 2 competing theories. The defense argued an accidental fall from the top of the stairs. The prosecution argued the husband beat her with a blowpoke, a fireplace poker rod. It also came down to 2 blood spatter experts who directly contradicted each other, Duane Deaver for the prosecution and Dr. Henry Lee for the defense. After 5 days of deliberations, the jury believed the prosecution. The husband was convicted of first-degree murder and received a life sentence. That was October 2003. And that was that. Until 8 years later, in 2011, a North Carolina state crime lab scandal surfaced, and during related proceedings, a judge found that Duane Deaver, the state's blood spatter analyst, had given deliberately false testimony in that 2003 trial. So the husband was granted a new trial and was released on bond pending that retrial. But rather than put his family through another trial, he opted for an Alford plea of voluntary manslaughter in 2017, essentially asserting his innocence while conceding that the state likely had enough evidence to convict again. He was sentenced to time served, and the case was closed. Those are the facts. But the story the media told was a little different, and not just because it focused on an object rather than the victim. The staircase. If you've seen any of the docudramas about this case, what I'm about to say will sound familiar, but I'm not here to retell it or to debate guilt or innocence. I'm going to focus on parts of the actual case the docudramas didn't cover, using the victim-villain motive resolution template. Starting with the victim, Kathleen Peterson. She was a successful tech executive, well-liked, and by all accounts, well-loved by her family. Yet, within 3 months of her death, the story became about something other than Kathleen. Every franchise that propelled her case to fame was titled after the object she died on. Kathleen became the occasion for the story, not its subject. The villain, cast almost immediately, was her husband Michael, a well-known local author. The casting had help, though. The prosecution and the media portrayed him as a philandering bisexual spouse who did not behave as expected when first responders arrived. And then the motive, the official theory on motive was rage tied to the affairs because the prosecution introduced his extramarital contacts and bisexuality as a motive narrative early in the trial. But that's doing double duty. It's not just alleging motive. It primed the jury's moral judgment about who the defendant was, independent of what actually happened to Kathleen Peterson. And it's worth noting now, because I am going to come back to it later on, motive was never something the state had to prove. It was something the story needed. The resolution seemed very clean. First, that conviction in 2003. But then, after the crime lab scandal vacated that conviction and mandated a new trial, the resolution became the Alford plea in 2017. But that's another case where the media's need for a tidy ending collided with an outcome that's legally ambiguous by design. Because innocent, the state has enough evidence, implies guilt, all of that are sitting in the same sentence. But that was the story that we were told. Essentially, it was a man, a motive, and a staircase. But the actual trial wasn't really about the defendant's character. It was more a referendum on whose blood spatter story 12 people were going to believe. And how they made that decision is where this gets a little interesting. So how do jurors resolve ambiguous forensic testimony when no confession exists? Because in this case, remember, we've got no confession, we've got no weapon, and we have no witness. And jury selection took 8 weeks because of how saturated the local media coverage already was. So at this point, the jurors are arriving with the case already partially solved in their own heads. And then everything came down to which side's blood spatter story the jury found more believable, which is a fundamentally different cognitive task than weighing a confession or an eyewitness account. Because jurors were being asked to adjudicate a technical, methodological dispute that they had no independent way to verify. But their gut reaction and the expert narrative lined up, because the prosecution's blood spatter theory of a beating matched what the jury already felt looking at the photos, which likely made Deaver's, or the prosecution's, testimony feel confirmatory rather than persuasive on its own merits. And that's a dangerous combination. Emotional intuition reinforced by a witness claiming that he has looked at over 500 bloodstain cases, he's written 200 reports, and he's testified in 60 cases. Compare that to the defense, who had its own blood spatter expert, notable Dr. Henry Lee, who was at that point at the height of his credibility and had genuinely impressive qualifications. There was also additional evidence, because in Kathleen's tox report was a blood alcohol level of 0.07, which was just under the legal limit of 0.08 at that time, and also some Valium. So the jury had competing narratives, and by their own account after the verdict, they resolved the tie with emotion rather than methodology, which is exactly the scenario that expert witness research says juries are worst equipped to navigate. But one more element was introduced, and that was the 1985 death of Elizabeth Ratliff, a family friend of the defendants from when he and his first wife lived in Germany. She was found dead at the bottom of her own staircase, not by him. But the prosecution introduced her death as similar facts evidence. I'll get into more detail on that shortly, but I'm mentioning it here because it also activated something called attribution error, the tendency to explain behavior by character rather than circumstance. And the prosecutor's closing arguments are worth noting here for their effect. On Agent Deaver, Duane Deaver, she said, "You know what? They're state employees just like most of us who work here at the courthouse, and they work for your state. They work for your state, North Carolina. They are tried and true because they work for us. But then on the defense experts, she was dismissive, hostile, and demeaning, yet emotionally persuasive, because she made it very clear that she was skeptical of anyone not from Durham, saying at one point, we're just going to have to get rid of them all. Hire some new ones from Connecticut, I guess. Jurors' own stated reasoning after the verdict was that the sheer volume of blood and the number of lacerations felt inconsistent with an accidental fall. That's a visceral read of gruesome exhibits, not a technical assessment of spatter mechanics, angle of impact, or cast-off patterns. The concept underneath this is called the epistemic authority heuristic, and it's the cognitive tendency to defer to someone's conclusions based on their perceived institutional status, rather than evaluating the actual methodology. Jurors don't assess how an expert knows something. They assess whether the expert seems credible. Confidence, credentials, and institutional affiliation substitute for methodological rigor in real-time judgment. And Agent Deaver passed that test for 25 years. That's not a personality failure. It's a predictable output of how humans process expertise. So now the jury was navigating two competing expert stories with no forensics training and no way to independently verify either one. And they resolved it in the way humans almost always do: gut feeling dressed as reason. But what we haven't really gotten into yet is how the prosecution helped shape what that gut was working with before a single blood spatter photo ever hit the screen, because the law gave them a tool and they used it. The legal term for what I want to talk about is 404B. And if you've spent any time around true crime coverage or legal podcasts, you've heard the term. It comes from the Federal Rules of Evidence, and at its core, it's a prohibition. You cannot introduce evidence of someone's prior acts to argue that just because they did something bad before, they probably did it again. The law calls that propensity reasoning, and in theory, it's not allowed. The catch is what comes right after the prohibition, because 404B explicitly permits the same evidence when it's offered for a different stated purpose: to show intent, to show motive, or critically, here, the absence of an accident. And that carve-out is exactly what the prosecution used to bring Elizabeth Ratliff's death into Michael Peterson's trial. Here's what made that legally significant and arguably legally troubling. The Ratliff death was not an unresolved question. A German autopsy in 1985 had already given it an official answer: natural causes attributed to a blood clotting disorder. So the prosecution wasn't introducing an open prior incident. They were inviting the jury to quietly override an existing independent medical determination without ever being required to formally prove that determination wrong. No burden of proof applied to the Ratliff case. They just had to get the coincidence in front of 12 people and let human pattern recognition do the rest. And pattern recognition is powerful. The underlying legal doctrine is sometimes called the doctrine of chances. The idea that if the same unlikely event keeps happening to the same person, coincidence becomes statistically implausible. And here we had 2 women, 2 staircases, 2 deaths. So the prosecution didn't even have to argue that the defendant killed Elizabeth Ratliff. They just had to make sure that the jury knew about her. What amplified that further was that the evidence didn't arrive alone. It landed alongside the evidence of the defendant's bisexuality and extramarital contacts, introduced as the motive theory for Kathleen's death. Individually, each piece was borderline, but cumulatively, they constructed a moral portrait of the defendant, methodologically, legally. And that portrait ended up doing work that the hard evidence about December 9th, 2001 could not do on its own. That's the stacking effect, and it's not accidental. One more layer worth naming. The defendant, Michael Peterson, he had adopted Elizabeth Ratliff's daughters after Elizabeth's death. Those daughters, Margaret and Martha, they remained among his most steadfast defenders throughout all of this. So the similar facts evidence didn't just create abstract prejudice. It directly contradicted the lived experience of the two people who knew that history best. That's the human cost of a procedural legal maneuver. The takeaway here is that similar facts evidence is most dangerous exactly when the similar fact already has its own official explanation, because it lets a jury relitigate a settled death by implication, with none of the evidentiary rigor that would actually be required to formally reopen it. So we have a jury primed by media saturation, swayed by an expert with pretty good credentials, or so it seems, and presented with a 17-year-old death that had already been ruled natural causes. What they didn't know, though, and what nobody outside the state knew, is what was happening behind the scenes. And that's where this goes from a story about one trial to a story about a system. So the Deaver Scandal. Let's start with the scale. The state audit found that the crime lab had withheld or misrepresented evidence in more than 200 cases between 1987 and 2003. Duane Deaver personally accounted for 34 of those. He was operating inside an agency-wide pattern of failure, not as an isolated rogue actor. His actual qualifications had gone unchallenged for 25 years. He had a zoology degree, 2 completed courses in bloodstain pattern analysis, and was not a member of any professional bloodstain analysis organization. According to the state's own assistant director, Deaver had written 47 reports, not the 200 plus he claimed in court. And he had testified in exactly 4 bloodstain cases, with the Peterson trial being his 3rd, not the 60 he claimed. So the jury that convicted Michael Peterson built their verdict on testimony from someone with fabricated credentials and misrepresented methodology. And the institution that put him on the stand either didn't have a mechanism in place to catch it or looked past it. His other cases tell the same story in different phases. A man named Greg Taylor served 17 years for a murder in Raleigh before being exonerated, in part because Deaver had withheld blood evidence at his trial. Another man, Kirk Turner, was acquitted of killing his estranged wife, and he later sued Deaver directly, alleging that he and a colleague had built a blood test theory backward from a predetermined conclusion, which is not science. The North Carolina Supreme Court allowed that lawsuit to proceed in 2016. But even after Deaver was fired in 2011, the state's Human Resources Commission ruled in 2014 that he should have been demoted rather than terminated. Yeah, I couldn't believe it either. And worse, they awarded him 34 months of back pay while still affirming he'd committed perjury. Believable. The second thing I want to bring up is that there were some clear jury and media boundaries that I don't think were really brought to attention. The first is reporter Sonia Pfeiffer, because during the jury deliberations in 2003, she was with local WTVD and was reporting on the case. She sent a letter to the deliberating jurors requesting a post-verdict group interview. And in that letter, she commented that they were all Team Peterson. One juror turned that letter over to the court, but the judge just instructed the jury to disregard it. He did not declare a mistrial. It's a reminder of how close to the line the media contact can get during active deliberations, and how much discretion a judge holds in deciding where that line sits. The other issue was the documentarian. I don't speak French, so sorry if I am butchering this name, but Jean-Javier de Lestrade, who was not an unknown quantity when he arrived in Durham in late 2001. He had just won the Academy Award for Best Documentary Feature for Murder on a Sunday Morning, a film about a wrongful arrest in Jacksonville, Florida. Which means he showed up as an Oscar-winning filmmaker with an established track record of sympathetic portrayals of defendants. The defendant and his attorney granted him full embedded access to the defense team before the trial even started. And what followed was genuinely unprecedented. A documentary crew inside an active murder defense, capturing legal strategy sessions, family dynamics, and the trial itself as it unfolded in real time. The original documentary premiered internationally in 2004. De Lestrade returned to the story multiple times as the legal saga continued, through Peterson's release in 2011 and the Alford plea in 2017. And his body of work helped define what long-form embedded true crime documentary could look like. So that part of it's good. But the question of effect is worth sitting with, because jurors were instructed not to follow media coverage, as they usually are. But the cameras were physically present in spaces adjacent to the courtroom and inside the defendant's home throughout the proceedings. De Lestrade's access didn't just document the case. It gave Peterson a visible, ongoing audience and an implicit framing. The man allowing this level of transparency has nothing to hide. Now, whether that posture influenced how the defense team behaved or how Peterson himself performed under scrutiny is speculative. But it's still not a trivial question. And just fun fact, when HBO released its 2022 dramatization, The Staircase, starring Colin Firth, De Lestrade publicly criticized it for, quote, recklessly blurring the lines between fact and fiction. That's a pointed complaint from a filmmaker whose own access arrangement had already complicated that line from the beginning. Okay, so earlier in this episode, I mentioned that I was going to drag you down a rabbit hole with me. And here's where we're going to go, so hang on. And this is a very weird rabbit hole, because when I was watching one of the mini docudramas while researching for this episode, I was kind of half paying attention, but I heard somebody mention Larry Pollard's owl theory. And honest to God, I was yelling at the TV, like, how stupid can you be? This is insane. But then I looked up from my laptop and I saw the autopsy photos of Kathleen's scalp. They looked exactly like talons of a bird of prey. I kid you not. I was floored and completely in disbelief. So I went down my own little owl rabbit hole, and what I found out is this. So first, on the mechanics, there was a 2014 Journal of Experimental Biology study, and that study found that an owl weighing under a pound can strike its prey with a force equivalent to roughly 150 times its own body weight. Enough that researchers noted that it could plausibly cause blunt force style trauma on a human scalp, even though the bird itself is small. And then the second thing was that owl attacks on humans, they are real. They do happen. They're rare. And they're almost always defensive, not predatory. And most documented cases happen near active nests during breeding season, when the bird is trying to drive off a perceived threat, not hunt something. Fun fact, the most common species involved are great horned owls, barred owls, northern hawk owls, and snowy owls. All very cute owls in my opinion, but wow. And then there are cited cases of owl attacks. The most cited being a 2015 series of barred owl attacks on joggers in a Salem, Oregon park. There were reports of repeated silent dive bombs targeting the head of people, with victims left with multiple half-inch talon cuts, but nothing life-threatening. Fatalities are essentially unheard of, but there is one widely cited historical case from 1985. A truck driver named Robert Schmidt was found dead on a California roadside near Los Banos. The medical examiner described his body as being covered in chicken scratches, which were concentrated on his face and his chest. The coroner attributed his death to shock following an owl attack. I'm telling you, I really went down a rabbit hole on this, and I still can't believe what I found. What I did not expect to find, on top of these other three things, was that Larry Pollard's owl theory, as wild as it sounds, got some real expert backing. So Larry was the Petersons' neighbor and himself an attorney, and he had several qualified people examine the trident-shaped wound pattern, the tiny feathers found in Kathleen Peterson's hand, and the timing, which was December, which apparently is owl territorial mating season. Kate Davis had a zoology degree from the University of Montana and was the founder of the nonprofit Raptors of the Rockies. Dr. Alan Van Norman was a DVM and had a PhD at the University of Minnesota College of Veterinary Medicine. He was also founder and director emeritus of the University of Minnesota's Raptor Center. And then Dr. Patrick Redig, a board-certified neurosurgeon and former U.S. Navy surgeon with an MD from UC Irvine. They all looked at these wounds, and they all concluded that her injuries were consistent with an owl strike. And I believe it was Kate Davis who specifically said a barred owl. So qualified and respectable people covering three aspects: behavior and ecology, veterinary biology, and wound morphology. That said, it's important to note that this theory was never tested in court. The 2017 dismissal motion succeeded on unrelated evidence handling grounds, not the owl argument. Plus, the owl argument has real critics, which I completely understand. So, though it's genuinely expert-supported speculation, it's not an established finding. So I'm not saying an owl did it. I'm just saying that my little rabbit hole had me no longer yelling at the TV. So we've covered the case, the courtroom psychology, the legal mechanisms that shaped what the jury saw, and the institutional failure that undermined what they heard. Before closing thoughts, so let's just check in on where everyone actually landed, because the aftermath of this case has its own story. The franchise named after the object Kathleen Peterson died on has generated 2 documentary series, a scripted HBO dramatization, years of civil litigation, and a genre-defining argument about what true crime owes its subjects. Yet Kathleen's name is not in the title of any of it. Kathleen Peterson was 48 years old when she died. She was a senior director at Nortel Networks, the primary earner in her household, known by colleagues and friends as warm, capable, and well-liked. Her daughter Caitlin, from her first marriage, came to believe Michael was responsible and filed a wrongful death civil suit. She won a $25 million judgment in 2007. As of 2017, Peterson had not paid $1 of it. With interest at that point, she was owed about $30 million. Her attorney's public position was that she just did not want him to profit from the case in any way. And a sad fact is that she has since publicly split from the Ratliff daughters, with whom, by all accounts, she had been extremely close with before her mother Kathleen's death. The civil judgment, thus, is the only formal accountability that actually landed, and it remains uncollected. Sonia Pfeiffer, the reporter who sent the letter to the deliberating jurors, she left journalism. She married David Rudolph, the defense attorney, in 2007, and now practices law alongside him at Pfeiffer Rudolph in Charlotte. So the reporter who tried to reach the jury is now the defense attorney's law partner. The Peterson sons diverged sharply. Clayton has remained supportive, but around 2021, 2022, Todd publicly broke from his father in a series of social media videos, accusing him of killing not only Kathleen, but also Elizabeth Ratliff, and even his own mother, Patricia, who died in August of 2021, still publicly maintaining her ex-husband's innocence. Kathleen's sister, Candace, came to believe that Peterson was guilty also, and has been very outspoken. She's also said that the documentary coverage has used her angry moments in ways that unfairly cast her as the villain of a story she didn't choose to be in. Jim Hardin, the Durham County DA who prosecuted the case, he became a Superior Court judge shortly after the trial and served for over a decade before he retired from the bench in 2021. Frida Black, his co-prosecutor who delivered the closing arguments, she left the DA's office in 2005. She ran 2 unsuccessful campaigns for district attorney, stepped away from the law, and then died in 2018 from complications related to chronic liver disease. Larry Pollard, the neighbor and attorney who championed the owl theory, he's retired, still in Durham, and reportedly his office is still cluttered with trial maps and stuffed owls. So that's where everyone ended up, and that's where the case ended up. But I have some final thoughts before we go. First, motive is not a legal requirement in a murder trial. The state doesn't have to prove why, only that the defendant committed the crime beyond a reasonable doubt. But motive is a psychological requirement for human beings trying to make sense of violence. We need a why, the same way we need a subject in a sentence. And when the prosecution offers one, even one built from speculation, from sexuality, from a death in another country 17 years earlier, it fills a cognitive gap that the law never required them to fill. In this case, the motive narrative was assembled from pieces that individually didn't prove anything about what happened on that staircase in December 2001. Together, they told a story about the kind of man the defendant was. But once the jury had that story, everything else, the blood spatter, the lacerations, the competing experts, got filtered through it. The science became secondary to the character verdict. That's what manufactured motive does. It doesn't replace evidence. It shapes how evidence is read. Which brings me to the other thing this case really highlighted for me, and that's the gap between how science works and how the legal system works. Science proceeds by continued questioning. A finding isn't valid because it's established. It's valid because it's survived repeated attempts to disprove it. The adversarial legal system resolves disputes between 2 competing stories based on legal precedent, cases that have been tried in the past. It doesn't run experiments. So when scientific testimony enters a courtroom, the jury doesn't get the ongoing debate or the methodological critiques. They get, Agent Deaver has been doing this for 25 years, and that's what they weigh. To me, that's the story the staircase is actually telling. Not a man, a motive, or a murder weapon, but a system that trusted its own story more than it trusted the science it was supposed to be evaluating. And a woman named Kathleen, whose death became the occasion for every other narrative except hers. And that's a wrap on this episode of Mind Motive Media. Thanks for joining me again, and a big thank you to everyone who's listened to the first several episodes, gave me feedback, and told your family and friends to listen. Please keep it up. I sincerely appreciate it. If this is the kind of analysis you've been looking for in the true crime space, or if you just really like what you heard, please follow the show on Apple Podcasts, Spotify, or wherever you listen. And if you're willing to leave a review, it genuinely helps other people find the show, and I would really appreciate that. If you'd like to continue the conversation on this or prior episodes, you can also find me on Instagram, Facebook, and X. I'll see you next time.